Welcome to We're the We and We the People. I'm Dr. Cynthia Newton, Chair of the Department of History, Politics, and Society, and Associate Professor of Political Science at Wesley College in Dover, Delaware. I'll be hosting today's program. But before we begin, there are a couple of things you should know about the League of Women Voters, which is the organization producing this series. The League of Women Voters is a nonprofit, nonpartisan organization. As such, they do not support political candidates or political parties, but do take stands on certain issues. And after providing countless voter registration sessions, informational programs, and other events, they realized that a lot of citizens don't really know a lot about how our government works at the national, state, or local level. Some of you maybe never had a basic civics class, or maybe you had one and forgotten what you learned. This applies even to some of our league members. And we hope this series will remedy some of that lack of information. This series is funded in part by a grant from Delaware Humanities. And today's segment is titled The Us National Judiciary. And as I talk about the National Judiciary, by that I mean our legal system and our means for enforcing laws and for resolving disputes that may arise. And we, arguably need to have a national judiciary because we consider ourselves a nation of laws. We have a foundation in the Constitution, and we have a foundation in a legal code, and we live under what is called the rule of law. Basically, that no one is above the law and everyone is equal under the law. And those ideas of being a nation of laws and the rule of law are a foundational element of our judicial system. Now, I'm going to focus largely on our federal court system, looking at the lower federal courts and the Supreme Court, with most of the focus on the Supreme Court. I'm going to talk us a little bit about the Constitution, the framers, as I mentioned, the lower federal courts, the Supreme Court, how they hear a case and issue an opinion, and then some of their big landmark decisions, to give you some examples. Article 3 of our Constitution establishes the Supreme Court as the top court in the country, sets up its jurisdiction and the terms of office for the Supreme Court justices. They serve during what's called good behavior, meaning that as long as they don't do anything wrong, they can serve their appointments for lifetime tenure. And this is important and was designed as such by the framers so that they were not beholden to elections, campaigning, and the whims of voters and other political concerns. Supreme Court justices are appointed by the President and confirmed by the Senate. And Congress sets up the lower federal courts. So we needed a national judiciary as the nation was just being born, and go back to the 1780s, and the first attempt at government of the Articles of Confederation did not have a national judiciary, did not have any means for settling disputes which might have arisen between various colonies or even between the colonies and the national government. And so quickly, this was something that they wanted to remedy. Even though it exists and sets up a Supreme Court, the details of Article 3 are generally vague and open to interpretation. And by this, I mean, I'm going to talk a little bit more detail in a little bit about the implied powers and how the Supreme Court got the definition of what it actually does and what we understand today that it does. But let's talk a little bit about the lower federal courts. As part of the checks and balances of Congress setting these up, and again, this is in Article 3, they are able to hear cases of either things that the Supreme Court does not need to decide, or they become a filtering system to get to the higher federal courts and then ultimately to the Supreme Court. There are two types of federal courts. The first are what are called constitutional courts, and these exercise the judicial powers of Article 3. And justices in the constitutionally created courts serve during good behavior, again, that they have lifetime appointments. These fall under two types of constitutional courts: the district or trial courts And the U.S. and its territories are divided into 94 separate districts, and they hear cases related to federal crimes, federal civil suits, admiralty and maritime disputes, federal agency overview, and anything else that Congress assigns to them. And then from there, the next step up the ladder is the Court of Appeals, the appellate courts. And the 94 district courts are organized into 13 regional circuits throughout the U.S., and they hear appeals from these lower courts. They also hear appeals from regulatory commissions, tax court, and Court of International Trade. The second type of lower federal court are legislative courts, and these are created by Congress for specific purposes. Judges typically have fixed terms and can be removed from office, and these include things like tax court and bankruptcy court and the military court of appeals. So if we look at the Supreme Court, now that we've gone through the lower federal courts, there are two types of jurisdiction, and this is in the Constitution for the Supreme Court. The first is original jurisdiction. This means that the U.S. Supreme Court is the first and only court to hear a case. The second type is its appellate function and its appellate jurisdiction. And this is what I mentioned earlier with the federal courts, that it rises through as a filtering system, and cases get to the Supreme Court on appeal. So the Supreme Court in Article 3, there's no real detail on what exactly the court does and how they function. It's not specifically enumerated. Yet the government started, hearing cases as early as 1789. There was a case they heard in 1803 called Marbury versus Madison. And while this is not the most earth-shattering landmark case, it's about a failed presidential appointment, what it did was set the tone and set the standard for what the Supreme Court does. And basically that they are the ones that interpret the Constitution, and that this is an implied power of Article 3. So they function under the idea that this is an implied power. Now currently we have 9 Supreme Court justices. The number is not specified in the Constitution. In 1789 there were 6. We've had as many as 10. Yet in 1937 there was a situation where FDR decided that he did not like that the Supreme Court was striking down a lot of his New Deal programs, and so threatened to appoint a new justice for everyone over the age of 70. This was called a court packing scheme, and so Congress passed a federal statute setting the number at 9. Again, it's not in the Constitution, but there is federal statute on it, so that we do have 9, and have had 9 since the late 1930s. Now, the president gets to nominate a new justice when there is a vacancy, and the Senate Judiciary Committee investigates, holds hearings, interviews, and then the whole Senate votes to confirm. And there's certainly a lot of politics and ideology, even though the justices serve these lifetime appointments to remove some of the politics. Again, as I mentioned, the president will choose someone that they want in line with their philosophy, how they're going to approach the law, and how their party thinks that, this is important. So the politics and ideology definitely come in. Another thing related to the Supreme Court that is in the Constitution is that the leader is the Chief Justice. But this is really someone who's more of a first among equals. They preside over case conferences, assign writings of opinions, preside over the impeachment trial of the president. And even though the role is largely symbolic, it can be very powerful. And for many, particularly in news and historical coverage, they become the embodiment of the court. And they can also help to mold its image and set kind of the tone for decision making. When there is a vacancy amongst the Chief Justice, the president does get to nominate the person that gets to fill that seat. The Supreme Court hears cases from October to April, And they do issue some of their opinions as they're decided, but the most controversial and big ones they save until the very end of their term and typically release them by the end of June. And the Supreme Court, in terms of actually hearing a case, they pick what they want to hear on appeal. If they choose not to hear a case, that's the same as making a decision. And that's the end of the road for that case. 4 justices have to agree to take on a case. And they typically look at things that have a significant federal or constitutional issue. Perhaps there have been conflicting constitutional interpretations from various jurisdictions, or something that rose to the highest level of its state court and wants to appeal to the Supreme Court. Typically, the Supreme Court hears about 80 to 100 cases a year, and they filter this out of about 7,000 to 8,000 different petitions. And so next I'm going to talk a little bit about what they do when they actually hear these cases and the types of opinions they have. So if you want to petition the Supreme Court to hear your case, the petition is actually called a writ of certiorari, or a writ of cert. And there's a whole process, there's a format, there are fees involved, although the fees can be waived if you demonstrate that you indeed do not have the means to cover the costs. And once certiorari is granted, the lawyers on both sides submit briefs. This is the history of all the major actions, decisions, and other events related to the case. And then the case is put on the calendar and oral arguments are scheduled. And when the oral arguments happen, each side gets 30 minutes, which is not a lot of time to present their case. Which is why it's important to have very experienced litigators arguing your case. The stakes are high, the time is limited, and there's a good chance that you are going to be interrupted and asked questions by at least one, if not many, of the justices. This is often by many people who watch these things, and academics and scholars will point out that you can get a good idea on the leanings of particular justices by the types of questions they ask. Now, about 50% of the time, the U.S. is a party in a case. And so when this is the case, the Solicitor General, who is the top trial lawyer for the U.S. government, is the one to argue the case. So after they've heard the oral arguments, prior to going into conference to debate and discuss and decide how they're going to see the outcome of the case, the justices might also consider other things, like law journals, actions in states, even actions in other countries, and something that are called Amicus Briefs, or Amicus letters. And these are letters or statements in support of one side or the other of the case by individuals, organizations, members of Congress, states, that have a particular interest in one side or the other of the case, but are not a party to it and want to let the justices know why they, should favor one side or the other. So that once the justices go into conference, as I mentioned, the Chief Justice speaks first, votes last, and then the justices discuss the case and they vote on how they are going to proceed. Now, 4 types of opinions they may offer. The first is called per curiam. This is a brief and unsigned statement. Roughly 50% of the opinions that the Supreme Court issues are unanimous. Most of what they hear is administrative, not really a big deal, or involve a very limited number of parties, have a very limited scope. The second type is what's called the opinion of the court, or the majority opinion. And these are obviously the justices that are in the largest number and in the majority. The third type is a concurring opinion, and this is typically written by a justice or justices who agree with the finding of the court, but for different legal reasons, or else want to highlight or illustrate a specific legal point. The final type is the dissenting opinion, and these are for justices or justice who disagree with the majority opinion. So as I mentioned, roughly 50% are unanimous. Most of what they talk about and decide is not that exciting, is not that earth-shattering. Yet when it is, those are called landmark cases. And these have a significant impact on U.S. law, U.S. society, or governmental function. These are the ones you tend to learn in school and we remember for long periods of time. And I'll give you just a handful of them. While there are many more and span much bigger chunks of history, at least these will give you an idea, and you've likely heard of at least one or two of these. So I'll start in 1896 with the case Plessy versus Ferguson. And in this case, the Supreme Court said that separate but equal accommodations based on race, and in this case it was referring to train cars, was okay. That this was perfectly acceptable, and this legalized racial segregation in this country for the next roughly 60 years. So related to this case, I have to mention Brown versus Board of Education of Topeka, decided in 1954, and this is where the court looks back and says, you know what, separate but equal is not okay. It's not even equal. And that the public schools in the states must be desegregated. This marked the early stages of the civil rights movement and certainly sparked a lot of protest, a lot of violence, and several decades of ensuing actions related to civil rights and related to race in this country. Third case I'll mention is Miranda v. Arizona, decided in 1966. And the holding of this case is that suspects actually must be informed of their constitutional rights after they are detained by law enforcement, but prior to questioning. And it must be clear that they understand what their rights are and that they can have legal representation. Moving a little further forward, 1973, Roe versus Wade. Now this case was essentially decided as a privacy argument in the 14th Amendment, but what it did was legalize early abortion in this country, and this has been the subject of much controversy for the last several decades and has resulted in several dozen more cases related to the topic of abortion and states and the national government making laws on it. And finally, these last two that I'm going to mention are related, is D.C. versus Heller, which was a case decided in 2008. This was a big Second Amendment case, the right to bear arms. And this was the first time in nearly 100 years that the Supreme Court had taken up this issue, largely because it's so controversial. And in this case, they affirmed that the ability to own a firearm is an individual right, not for the purposes of militia or military. And as such, the District of Columbia, our nation's capital, could not ban handguns. And related to this in 2010 was the case Chicago v. McDonald, which took the D.C. versus Heller finding and applied it to the state level as well, so that states could also, and counties also, could not ban handguns. And obviously there are many, many more that you could look into, but at least this gives you an idea of the type of stuff that becomes the source of big landmark cases. Now, to wrap this up and bring it together, I'll mention that the Supreme Court has the highest approval ratings of any of the federal branches. People tend to like the Supreme Court. And this could be because it's somewhat shrouded in mystique. There's a lot of their private deliberations and conferences that we're not party to. We don't vote for them. They're not really in the news that much, except when there are huge cases or controversies or there's a particularly colorful judge, and there are only 9 of them in a country of over 300 million people. So likely, most people have never actually met a Supreme Court justice. Yet they still can have a very substantial impact on the lives of citizens, particularly related to constitutional rights in the 20th and into the 21st century. And also looking at the evolution of the types of cases that our Supreme Court and the rest of our federal judiciary hears can show the evolution of our laws, our role, and our understanding of the U.S. Constitution. Hopefully this has given you a little more insight into our federal judiciary, and I thank you for your time.